Hi, good afternoon, everybody. Thank you for joining us for another episode of Condo Insider. So today we have with us Max Copper and Taylor Gray with Porter, Kiakona, and Copper. Got that one right. Forgot, and because it used to be PMK, Larima retired, so kind of get used to the new acronyms here.
Me too. I mess it up all the time too.
So thank you, both of you, for joining me today. So we're going to really talk a little bit about annual meetings, because with the state of condos right now, there's a lot of stress going on because of special assessments, because of the increase in maintenance fees, especially related to insurance, right? The rising cost of insurance. I think boards need to spend a little bit more time before the actual annual season starts in January to kind of be a little bit more prepared. Be prepared with anticipating certain questions that the condo owners might be asking and coming to the annual meeting, all huffy because, it went up such a big amount and now we got a special assessment we got to deal with, so I think they need to be a little bit more prepared with some information. And one of those things that I'm kind of trying to tell everybody, I go, you need to translate your budget more into like a pie chart of some sort. It's because sometimes that's easier for people to read than versus a spreadsheet of numbers, then they can kind of see where everything goes. And I know a couple condos that said that they have done that, and that actually is a lot more beneficial for them when they present it to their owners that way. They don't get as much, that argument or, those uncomfortable situations in a board meeting. The pictorial version actually means a lot more. But also with this legislative session, there was a new House bill that got passed, House Bill 2315, that is now Act 42, right? Related to annual meetings, electronic voting, and mail-in ballots. So the reason why I wanted to kind of do this, because I was reading the bill and I'm like, oh my God, there's too many steps. There's too many deadlines. I go, boards need to be really diligent on this and need to get real advice or someone to help them along with this. Because I know the mail-in voting, you have to, I think, start 90 days out or something before the annual meeting and meet some requirements. So kind of explain to us what the mail-in voting requirements are with Act 42.
Yeah, thanks, Raylene. Really good question. So post-COVID or during COVID, we had a lot of associations looking at both mail-in voting and electronic voting as an option. This new law was really intended to just clarify the process and not necessarily install new onerous deadlines, but just sort of clarify what the original intent was and allow associations the opportunity to do this. And so I'm glad you mentioned the 90-day deadline, because what that is actually is you have to get approval from the ownership to do the electronic ballot voting. And that is in the window, and you have a window in which to do it in. And that is under section 514B121, not to get too technical, but E4 is you have to get approval for electronic meeting, electronic voting, or mail voting by the owners within either it says not less than 3 months and no more than 18 months before the voting takes place. That sounds really complicated, but the intent of it is it's supposed to be done the year prior, or at least with enough notice. So it's not done, 10 days before the meeting and then it's going to be electronic meeting. And for all intents and purposes, it's kind of the way things are done, because no management company would agree to do electronic voting if they only got, sort of 30 days notice that they got approval for it anyway. And
Right.
so I think how this was envisioned to work is you would either vote on at the end of your meeting last year or this year, you would say, okay, guys, do we want to try electronic meeting this year? You could do it by a vote of the majority of those present. You don't have to do the 67% to amend the docs, but that approval is only good for that window of 3 months after and 18 months. So you have to renew it every year, and you have to do it. The easiest way is to do it the year prior. You do have some leeway. I just did one where we got a written consent back now. And so we were able to allow the electronic meeting for the upcoming, I think it's a March meeting. And so that's within the time period. But one thing I will advise boards and have been advising boards too is that's the legislature was nice to us, and they lowered the requirement to 50% as opposed to the 67%, which would have been needed to amend the declaration or bylaws to allow for this. So that's good. But if you don't want to vote on it every year and you think you can get 67%, you might want to look at that as an option so you don't have to vote on it every year. As Taylor and I were talking about before, one pitfall you might fall into is what if you don't make quorum the year prior and you push it out for a year? That's going to be past that 18-month window, and then you can no longer have electronic voting.
So, so it requires a 50% versus the normal 67%,
Correct.
right? So in theory, at the end of this annual meeting or during this year's annual meeting, they could, but they have to watch that 18-month timeline, right?
Right.
Could prep themselves for next year doing electronic or mail-in vote ballots, right?
Correct. And so what we've talked about is if you have an existing electronic vote, you add it to the ballot or you include it on the agenda of the in-person meeting, and then it's majority present. It's even less than 50%. It's majority present at the association. Whereas if you do it by written consent, it's 50% of the total ownership. So as long as you have quorum, all you got to do is get 50% of those guys there to say, yeah, we'll agree to electronic meeting.
50% of the quorum.
Of the quorum, yeah.
Oh, wow.
Yeah.
Wow. That is even lower, brings it even lower versus 50% of your total.
Right. Well, to be accurate, 50% of those present if it's above. Yeah.
Okay. Present in person.
Or by proxy.
Oh, by proxy. Okay. So total quorum in person or by proxy. So, okay. So 50% of that number. So that makes it can be potentially a lot easier.
Yeah. Yeah, it could be. And it's not you have to do it. It just authorizes the board to do it. So if you're thinking about it, the board can say, hey, we're going to listen to you guys, whether you want to do it or not. But as we're discussing this, just give us the authority now so we can decide later.
Yeah, because setting it all up is going to be time consuming. And I'm sure the management companies are going to have to figure it out as well along the way in preparation for next year, which might take, it could take 18 months for them to figure it out. Not figure it out, but, put the procedures and set everything up that they need to set up because it's something new that we don't normally do every month, right? So let's move on to resolutions. How can we, because I know Max, you had mentioned it, but Taylor, we talked a little bit about resolutions, getting the resolutions passed at an annual meeting. And I had a conversation with one owner. We were just kind of kicking things around. And she has board members that don't attend board meetings. One's been elected, has never attended a board meeting since. So she kind of wants to introduce something. And I was telling her, I go, yeah, the first condo I bought way back when, I remember reading in the bylaws that if you don't attend like 3 in a row or something like that, then you're automatically kind of like kicked out.
Right.
Removed.
So how does that work?
Well, something that drastic is going to be by a bylaw amendment. So that you would need 67% approval from the ownership. So it's not going to be like what we just discussed with this electronic meeting where 50% of the majority present can effectuate a change like that. You are going to have 67% of the owners for 514B, and then 421J, depends on what their governing documents say. But for 514B, you're going to need to have 67%. So if 67% show up at that annual meeting and they all vote in the affirmative, that's something you guys can do at an annual meeting. But let's say that's very hard to do. It's very rare to get that much owner participation nowadays. So if you only get 60% attending or by proxy, you're not going to be able to implement an amendment like that. You're going to need to either do a written consent to get that 67%, or you're going to need to do a crazy mail out campaign, or to get a large amount of participation at that next annual meeting to make sure you get that 67%. But with that being said, to answer your earlier question, there are certain resolutions for sure that can be implemented without 67% owner approval to amend the bylaws, like a corporate tax rollover resolution, or even meeting rules, giving certain owners a certain amount of time to speak at meetings, rules dictating the meetings, but anything that dictates what the eligibility requirements of a director is going to need the ownership's participation and affirmative vote.
Yeah, so an easy resolution would be something more procedural.
Yeah, to dictate. That's fair to say.
Okay. Sorry, what was it, Max?
No, I think an important point to make, though, and I think maybe the one of the points the owner you were speaking to was trying to make is how does the owner participate, and how does the owner have control? In the rare situations Taylor's talking about where you do have high participation, an owner can bring an amendment at the meeting. The meeting, what I like to draw the distinction is a board meeting is a meeting of board members, right? That is the assembly. That is the group that is meeting. An annual meeting, that is your meeting. That is the owner's meeting. And so an owner can bring an action. They can bring a motion to amend the bylaws. Whether or not it's successful is rare, as Taylor puts it, but you can do it. Same to the point of your resolution. Owners have a lot of power in the annual meeting, certainly when compared to the board meeting. And so, yeah, it might take some sort of Googling legwork, maybe talk to your lawyer friend about what sort of motions can be brought by resolution rather than a bylaw amendment. But there are certain things, procedurally, yes, but that procedure can affect a lot of things too. The way meetings are conducted can affect a lot of things. The way information is distributed, that could be a motion that is passed at a meeting. So.
And to piggyback off that, even it doesn't need to be at an annual meeting. If that owner gets 25% of the ownership to petition the board to send out a written consent to amend the bylaws, that can be done as well. So that they have a little bit more time to get those petitions signed by the ownership to try to get an effectuate change.
Really good point. Yeah.
So like, if the board wanted to make do a resolution, and so would they have their legal counsel type up the resolution and they could include it in their annual meeting packet that gets sent out to the owners, and they potentially could say yes or no via the proxy?
Yes. So if the board, so let's say that you have a situation where you have a high participation rate, and the board doesn't want to do it by written consent, we would pass either the resolution, the bylaw amendment, whatever motion. Legal counsel would draft it. It would be included in the agenda and the mail out so that owners could review it, and then they could vote on it. Then you might have somebody in the audience bring it, or what, bring the motion. But in most of my associations, we actually ask, you can't require, but we encourage owners, if they are going to bring motions during the meeting, to give it prior, so we can include that in the agenda as well.
Wow, cool. Awesome. So how is it, have you guys been involved in any of the electronic votings yet? Because I know Canada's big on it. There's not that many states that allow for or have, provisions for electronic voting. There's like a handful of them.
Taylor, you got any? I got one, but I have a couple, but.
No, fortunately, I have not. I know there have been a lot of issues with the legislature and the statute requiring certain procedures that have inhibited associations from implementing such rules. So thankfully, my boards have not. But I would love to hear Max's.
Yeah, I've had three last year, and they're all newer associations that had it already in their bylaws. And so that was previously, that was kind of the only way you would see it, right? And so now, that the law's clarified and has made it easier, I think you're going to see a lot more of it in the next coming years. But it's basically, it comes down really into selection of the software. What, SurveyMonkey Vote, iVote, or all these sort of various softwares.
Okay.
And how, how those are done. And it dredges up all kinds of problems, because in one of mine, we had the bylaws were amended to allow for electronic voting, but there was sort of a contradictory provision that talked about the election having to occur at the annual meeting. So we were trying to do the electronic voting prior to, and whether, if you are amending your bylaws, you have to be very clear and very careful as to, did you catch everything? Because these bylaws were written before the internet was made, right? And so it's, yeah, there's a lot of pitfalls out there, but it was very successful. And
so you got better participation with electronic voting?
Yes, and I think the key for that was we did electronic voting prior to. So very similar to what the state's doing with mail-in ballots. I've also done that recently as well, where you have mail-in ballots and you set a due date prior to, so that they can be counted and read at the annual. We've gotten really high participation. And I do think that if once you have this prior to electronic voting done, you may be getting to the point where you'll get the participation to pass bylaw amendments in an annual. You'll get 80% participation, because all they got to do is log on to a website at one point in the next 2 weeks and press a button.
Because the mail-in ballot is going to be kind of interesting, because it's hard enough to even get them to turn in proxies.
The mail-in ballot is hard because this is Hawaii, so you mail it there, but they're not living in their unit. Or, this one I'm talking about was on Maui, where you have a lot of the, seasonal occupants. And so you don't know, do you send it to their Hawaii address, but now they're in Canada, and they send to Canada, now they're in Hawaii, I didn't get it, can you send me another one? Well, you have a problem sending out more than one. So that, oddly, electronic has much less problems than mail out because of just the logistics.
Yeah, so even that proxy stuff, just getting in that information out there. Yeah, so you're actually doing a dual mailing to some of those owners. You have their, the unit, then you have to mail it. I mean, because on the you might be having to mail it to the taxpayer address, right? To be on the mainland, and then you have the local address, which would be the property. So essentially, you're almost having to be pre-prepared to mail to both addresses.
Yeah, and you brought up an interesting point about proxies, that Taylor is actually working on something really interesting with one of his projects, and electronic proxies, possibly. Taylor, can you talk about that a little?
Yeah, we've been trying to implement a DocuSign or some other signature software where owners can generate participation for meetings. They can submit it entirely via email online to the general manager and the managing agent, and those signatures are verified just as if you would sign your closing documents via escrow. How you sign everything DocuSign, you would sign your proxies via DocuSign. And that way it's going to be instantaneous. You'll have a better idea of the ownership participation, how many people are going to attend, if you're going to have quorum. you can have those results almost immediately rather than waiting for the snail mail.
So how do you guys verify the signatures?
It'd be the same process. You have a closing that's worth, a multi-million-dollar property, and the banks are okay with you docu-signing that. And the reason is there's checks and balances, there's geotagging, and you make a profile where they verify your identity. And that would be state law actually acknowledges that those are equally as valid as a wet signature. So it all force and effect would be just as equally invalid under the statute.
And what Taylor's project, that what they're contemplating doing, is setting up the DocuSign form themselves. And so we're still working on the logistics of that. But I have another project who's accepting DocuSign, but they put the onus on the owner to set it up through their own profile, email it to them, and then we get the verification sent from DocuSign. That's all clunkier. What Taylor's guys are doing, and to answer your question about verification, is if you're the owner of the form, you vote, or if the association's the owner of the form, by you as the owner voting, it's going to all come to me. They have total control and custody of the verifications.
Right, exactly. Great point. They provide their email address, when they purchase or they opt into this process, and then you can verify that email address and verify it that way.
Because usually, like with a mortgage, we always have we take a copy of their photo ID, as part of the file. And even for the notary, they take that photo ID. So how would you guys do that? Because I'm not a big DocuSign thing, but even some documents where you do it electronically, you're just typing in your name and that's your signature, right?
Yeah, we're still fine-tuning the process, but mostly it would be when you register for the DocuSign, you'd provide your address, you would provide your email address that we would already have on file, and you would opt in. So you would confirm that you're going to submit this proxy. So in fact, it would actually, in most cases, I believe, be more accurate than having a random person who you've never seen their signature before attesting to, this is my proxy and I'm assigning it to this random person. At least this way, it's that individual, that they have that email. Granted, you're always going to have the same concerns if someone hijacks their email or sends it to somebody else, but you have the same concerns with a signature, forging a signature versus logging in with a password that person has registered to then assign that proxy electronically to someone else.
So is the system going to allow, like, if at a later date they want to change their proxy, they can submit another one?
Sure, I don't see why not. Like I said, we're at the very forefront of this, and we just verified the legitimacy and acceptability under the law to have this kind of more streamlined, to get owner participation, to get proxies turned around quicker. So if that's probably going to be one of the troubleshooting issues that we might run into, but we're not going to foreclose and we're not going to limit it only to electronic proxies.
Right.
So if somebody wanted to send it via mail, we would completely accept that. But this association, people tend to be a little bit more electronically inclined. It's a lot of Japanese ownership, right. And sending and translating is a lot harder to do. So if we're able to send that to them and they can send that back via electronic means, hopefully we can get some more ownership participation.
Yeah, even in your other other condos, there's a lot that when you're mainly non-owner occupant, getting those proxies back is painful. It's like you're up you're really hugging the phone and making those phone calls to get them to turn in the proxies. So doing that way might be easier, especially now that everybody's used to doing faxes. That was used to be the hard part. Well, can't you put it in a fax? Now we're over that hump, but now it's another electronic device that we have to, or a method that we have to get used to for everybody to do it. Because actually, they might be able to do it on their phone, right? Canada docs, you can do it on your phone. That I know. digitally signed through Panda Docs. So they might, that could be an avenue that'd be even easier if they could access it through their phone, right?
I think I signed my mortgage through my phone.
Yeah, there's some people, there's some MLOs that, I've never really seen my client until we went to the signing.
Yeah.
Yeah.
Like, really? Okay. All right. So I really, really want to thank the both of you for being here today, talking about annual meetings, especially the new House Bill 2315 Act 42 that really is really there to help along getting those votes in that we need so that we can do those annual meetings. Because a big hangup is always getting in those proxies to meet quorum requirements. There's a couple out there a couple condos that I've been hearing that haven't had an annual meeting because they can't get quorum. So I know one was, can't we find them? I don't know.
Yeah.
It's gonna have to figure that out. I don't know.
No, the answer is no, you can't find them. It's an elective democracy. But yeah, and we've had associations that are 5-6 years without an annual meeting. And the same directors have been running the place without any elections, and the owners just aren't interested, and it's not a good thing. It's always good to have.
Is there legal stuff against the association if they don't have an annual meeting?
Well, there could be claims of a breach of fiduciary duty of the directors if they're not moving. I think 1, 2, 3 years, that's not too bad. There could be claims, however, if it's 6, 7 years and they haven't done anything, because the statute does provide a method. 514B and 421J do provide a method for asking a court for judicial excuse. It allows for the court will they will give you an leniency for a quorum. They'll say, well, it's impossible for you to get 50% quorum, so I'm going to, by judicial decree, make it a 25% quorum. So at least that way you can have an annual meeting. You can get that tax rollover resolution adopted so that you don't have all these tax penalties as a nonprofit, and you can get new membership into director positions. And that way, it's a high standard. The court really needs to see that you've tried to get quorum,
right?
And there's a lot of check marks that they have to go through. But it's happened. We've done it on several occasions, and it's beneficial, I think, moving forward. And hopefully, with electronic meetings, that's not going to be as necessary moving forward.
Yeah, real quick, it's a great tool when, sort of in case of emergency, break glass, but it is a legal proceeding and it costs money, right? And so I think the step the legislature is taking with, catching up with the times and doing this electronic voting, allowing it much easier approval to do it. That's really the answer is, yes, we have associations that need what Taylor described is a really amazing tool to move things forward when there's just nothing else. But at the end of the day, we all want more participation. That's what's best for everybody.
Yeah, so it's opening the door for every avenue of ways of getting people involved. I mean, they bought the unit, they have an obligation to the association to participate, and be part of the community. So, any last words?
No, just anybody out there, vote, please vote. If you want electronic voting, bring it up at the annual meeting, and you can pass a motion, and then it could be approved for next year.
Yeah, and just because they pass the resolution, it doesn't mean that they have to, but it's there for them to explore it.
Right.
Okay. Anything, Taylor? Any last words?
Going off of that, you can have hybrid meetings as well. It's not to say that you only have to do it electronically. If people want to attend in person and some want to attend electronically, whatever works, whatever floats your boat, at least approving it the year prior gives you that option to implement that hybrid system so that you can get the most participation.
So if they do hybrid and electronic voting, that's a game changer.
You have a lot of, the elderly ownership that doesn't want to deal with all that new age technology. And then you have a lot of the newer people that they're, the recluses that don't want to go out, but they're willing to participate on their phone or via Zoom. So at least you hit all demographics that way.
Yeah, that's a game changer. Okay. Well, thank you guys for your time. I really, really appreciate it. This was eye-opening. I'm kind of looking forward to it, about, what could happen next year when they start doing their resolution changes and allow it and bring it, opening that door, because in some condos, it's kind of like a closed door. Now we have two avenues to make that door wider, for participation.
The legislature is finally catching up.
Yeah. Okay, so thank you, you guys. I really appreciate it. Have a great weekend. Stay out of the rain. I think we're expecting rain again over the weekend. But yeah, so drive safe and stay safe. I appreciate it.
Aloha. Thanks, Raylene.
Okay.
Thanks for having us.